Good afternoon, esteemed guests. I request you all to please make your way to your seats and settle in for an afternoon filled with intellectual stimulation and insight. I invite our dignitaries, please, on stage. The Finance Minister, Mrs. Nirmala Sitharaman, Judge Bennett, Lord Justice Colin Birss, Dr. Grabinsky, and Justice Prathiba Singh. And as the dignitaries come on the stage, I request Manmeet and Kanika to make this special afternoon even more special with a self-composed piece titled Make It Happen. Thank you, Manmeet and Kanika. Ladies and gentlemen, the dignitaries present on the dais, distinguished guests, esteemed colleagues, is better? And dear friends, good afternoon and welcome to the launch event of Justice Prathiba M. Singh's commentary on patent law. My name is Anusuya Nigam and I'm deeply honored to guide you through the program for today. We have the privilege today of hosting an array of eminent personalities who have graciously agreed to contribute their insights to this momentous occasion. I'd like to call upon Manmeet and Karmanya to extend a warm welcome to our guests and to kickstart the event.
Thank you, Anubi. Good evening, ladies and gentlemen. I warmly welcome all of you to the launch of the commentary on patents written by my mother, also known as Justice Prathiba Singh. We are honored to have amongst us various dignitaries and luminaries this evening. I would first like to extend my heartiest welcome to our chief guest, Honorable Finance Minister, Ms. Nirmala Sitaraman, and all dignitaries on the dais who've traveled from various parts of the world to be with us. We are also honored to have amongst us honorable judges of the Supreme Court and various high courts who have taken time out to be with us here today. We have also been joined by members of tribunals, regulatory authorities, esteemed organizations of the government, representatives of various embassies and consulates, senior advocates, members of the bar, colleagues, and friends from the IP fraternity. I also welcome members from the media who are here today. I would also like to extend a very warm welcome to all members of Singh, including Jagdish sir, wherever he is. Without him, an event is never possible to be conducted seamlessly. So thank you to Jagdish sir and the entire staff. A heartfelt welcome and a big thanks to the entire commentary team, without whom today would not have been possible. Lastly, and most importantly, I would like to welcome all our friends and the family members from Delhi and those who have traveled from Bangalore to celebrate today this momentous occasion. Yesterday was Women's Day and I got a message in the morning which reminded me it was. And I smiled at the thought that we had planned this event today because I truly believe that my mom is a superwoman personified. My mom had envisioned and commenced writing this commentary 8 years ago, and living by her motto of having every initiative turn into a logical conclusion, she has turned this endeavor of writing the commentary into a reality. So Amma, congratulations for another feather in your cap. You have led all of us by example and we are very, very inspired. On that note, I will not take more time, so I warmly welcome all of you and we can get on with the evening. Thank you very much and for always extending your support. Now I would like to call upon my brother to take on from here.
Check. I'm Karmanya Singh, and what I want to start with is to say that I love patents. My mom didn't make me say it, but being Prathiba Singh's son, I was surely drafting patent specifications before I was able to walk. But jokes aside, welcome to the book launch of Prathiba Singh on patent law. You'll notice that the name of the book is patent law. It's not Indian patent law. It's not patent law in India, and that's on purpose. You'll have received a booklet, and you'll see that the material does cover a lot of Indian patent law. But the issues that are discussed are global, whether that be computer-related inventions, efficacious drugs, litigation funding. These issues are right now pending all across the world, and technology is advancing so fast that we don't really know what to do. Today, if you ask a US attorney, a US patent attorney, about the Alice judgment in the Supreme Court, they'll just look away. They will not answer any questions. Europe is still figuring out enforcement in different jurisdictions, especially the European countries. And the Unified Patent Court, which just started in 2023, is their endeavor to solve enforcement issues in Europe. But enough about patents. Let me talk about my mom. We all know her as a very proactive, hardworking, diligent, disciplined lawyer and judge. She's been working to improve the understanding of IPR, but in general also improving the access to justice. I remember during the COVID-19 lockdown, when the restrictions were lifted, she was one of the first judges who wanted to run a hybrid court, when one of the lawyers would appear online through video conferencing and one lawyer would appear physically in court. And I remember going to a courtroom myself on a Saturday evening, working with their IT team, making sure that there was no echo, everyone could hear each other, and this has been the best use of my electrical engineering degree so far. The Delhi High Court in 2021 established the Intellectual Property Division. And the Intellectual Property Division has been coming out with some amazing jurisprudence for intellectual property enforcement, whether that be patents, trademarks, or copyright, and even designs. We know now that Delhi enforces intellectual property rights. In this spirit of proactivity and improving the understanding of IPR in India and around the world, my mom has written this book. So on behalf of all of the litigants, all of the inventors, the patent agents like myself, trademark agents, lawyers, and most importantly, the judges who will be deciding patent cases in India, thank you for making patent law a little bit easier to understand. We would now like to play a video for you to share your journey with the audience, with a special focus on when it all started.
Thank you, Manmeet and Karmanya. And what a beautiful video. Thank you for making it. As we saw in this clip, Mr. Salve was a great catalyst in encouraging Justice Singh to commence the writing of the commentary. Mr. Salve really doesn't need an introduction, but there's something I must say. Mr. Salve was part of many, many matters that, ma'am, may I just say ma'am, please? It just comes easier to me that way. That ma'am and the team were part of, and the list is long, Novartis, Roche versus Cipla. And back in the day, many times I was the youngest person on that team, and I have to say that the team, all of us here, will cherish forever those nights of sheer hard work that led to nothing less than magical days in court. Mr. Salve, unfortunately, will not be able to join us in person today, but he has sent across a video that we are going to play now. Thank you.
Dear Justice Prathiba Singh, or Prathiba as you're known to all your dear friends, it's my loss that I'm not there with you this evening in person. I wish I could have been there for you, because I have so looked forward for not just this evening but this moment. From the time I started working with you about three and a half decades ago, I have always admired the width and depth of your knowledge in the field of intellectual property law, be it the law of patents, the law of copyrights, law of trademarks. But what I have almost envied is your ability to explain complex propositions so simply by breaking them down into the elements and putting them side by side, so that even for the untrained or inexperienced mind, they become easy to grasp. I know this out of personal experience, the way we work together, how you explain to me complex notions of the law of patent when we did Novartis together, or we did some of the drug cases together. So that is why I used to also say this to late Arun Jaitley, that you should spend some time on academics and maybe even write a book. The reason being that somebody who has not just the knowledge but the ability to deconstruct a complex subject and put it simply is ideally suited to be an author of a treatise on a complex subject of law, a complex area such as the law of patents. And I've seen some of the pages which you have written, and I can say without fear of contradiction, this book will certainly occupy its rightful place alongside other recognized important treatises on the subject of intellectual property law. I wish this book all the success, and I wish you more and more books of this kind. Wish you all the very best.
The demise of Mr. Fali Nariman last month has been a huge loss to the legal fraternity. But some time ago, Justice Singh had requested Mr. Nariman's feedback on a few initial chapters of the commentary, and the feedback that we received from him was instrumental in the sense that it inspired a number of significant changes across the chapters throughout the commentary. I'd like to invite Manmeet on stage, and she'll narrate an incident from a few months ago that will give you a glimpse of the brilliance that was Mr. Nariman. Over to you, Manmeet.
Considering what Anuti just said regarding feedback, I would like to share a small anecdote that we experienced when we went to invite Fali sir for being with us here today. So the day Mom, I and the legal researchers went to his house to invite him. We had given him the contents which you may see in the brochure. So that contains only the first chapter, the indices, and the final chapter. The next day, I receive a call in the morning when I'm in court from Fali sir's office saying that sir wants to speak to you. So I pick up the call, and when Fali sir comes on call, he says, Manmeet, there are certain citations which are not there. So first I'm flabbergasted as to how we've not put some citations. Now after that, there is a downpour of emails and calls after calls where he is dictating citations to me one by one, that this is not there, that is not there, that is not there. And I'm getting scared and I'm flummoxed because my matter is being called. Finally, there is a final call during lunch. Again, there are citations after citations. And that call, he gives me a piece of his mind properly. And that it ends with him calling us absolutely hopeless. So I am petrified. First I call up the legal researchers and I give my peace of mind to them because I don't have answers to these questions, because knowing mom, I'm pretty sure there is not even one citation missing, let alone so many. So I'm asking them, where are these citations? Why are these judgments missing? And then I call her that this is what has happened, because now I'm scared that he'll be so angry that he won't even come. So then mom decided that she'll send the entire manuscript, the full manuscript, and 2 legal researchers to his office. All of them have gone. Full evening they have sat and highlighted one citation for him. And this evening ends with Fali sir asking both the legal researchers, do you want some rum? This experience actually shows me what kind of a taskmaster Fali sir was. It gave me a small glimpse, but it was very valuable. And also it was extremely inspiring to see that regardless of every circumstance, how thorough he wanted to be. We all of us miss him today, but when I told this story to my dad in the evening, he said, unki dant hi unki blessing hai. That he has blessed us with his scolding, and we are all blessed. So I'm sure that wherever he is, he's showering his blessings on us. In his very unique style, probably with a glass of rum on the side. On that note, I'm very happy that Neena is here with us today. I want her to share her thoughts and read the message that Fali sir wrote for the book.
Yeah. The message that my grandfather wrote is actually preceded by a handwritten note, which is very sweet. So I thought I'd read that first and then read out the message. Dear Justice Prathiba, enclosed is the blurb for your excellent book, Fali. So he starts with that. His message reads, Sir Owen Dixon, Chief Justice of Australia from 1952 to 1964, was once asked whether it was any part of the duty of a lawyer to contribute to the progress of society. And his response was that the only duty of a lawyer was to keep a hand on and hold steady the framework and foundations of the law. But this was in a century that has passed. In the new millennium, with the quickening pace of technological advance, along with a new sense of service and duty to society, the Dixon model has been replaced by intellectuals like Prathiba Singh. Having obtained a master's degree in law from the University of Cambridge with the help of a Cambridge Commonwealth Scholarship, Prathiba never forsook her sense of service and duty to society. Whilst practicing intellectual property law as advocate, she set up the Prathiba Singh Scholarship in 2013 for Indian students seeking postgraduate tuition at the University of Cambridge, thus helping a stream of needy and deserving scholars. Appointed judge of the High Court of Delhi in 2017, she has now exhibited her professional expertise in the field of intellectual property by authoring a book in 2 volumes on Indian patent law, one of the very few works on the subject. And he ends this message with this line. The last sentence in the book is good augury for the future of intellectual property in India. in the context of more and more diseases and health constraints which affect human beings, as also issues concerning climate change, there is a need to strive for responsible IP. This is my grandfather's message to you. I'm sure he's smiling on this function. Thank you. Thank you, ma'am.
Thank you, Nina. Joining us from the Federal Court of Australia is Judge Annabel Bennett. Judge Bennett's achievements include her role in shaping Australia's intellectual property landscape through her judgments and contributions to legal scholarship. Her work has garnered recognition both domestically and internationally, solidifying her reputation as a trailblazer in the legal profession. But more enduring than that was Justice Singh's description of Justice Bennett to me last week when I asked ma'am, I said, please tell me about Judge Bennett, tell me what she's like. And ma'am says, Annabel is my friend, and she is one person who has more energy and passion than even I do. And that's saying something. Without further ado, I present to you the vivacious Judge Bennett. Sure. That's working as well.
You can check that, it might be working.
Is it working? Yes. Well, distinguished guests, too numerous to mention, and of course, Prathiba. It's quite an honour for me to be asked to speak at this amazing event. But when I started thinking about it, I thought to myself, I was reminded of the song, the beginning of the song from The Sound of Music, if those of you who remember it, and it goes, how do you solve a problem like Maria? Well, of course, my immediate reaction was, how do you describe a person like Prathiba? This book, it represents an alignment of her interests and ability, her commitment, and of course, she was lucky to have the intervention of COVID, if anyone can call that lucky. And of course, if I can talk about her energy, and there's an awful lot of that. My overarching comment about the book is that it has superb analysis and breadth and depth. Not only does it give you a history of the development of patent law in India, including the various inquiries that made recommendations for the best practice, but it also gives you an analysis of relevant international law. And that's not an easy thing to do. But that helps Indian lawyers and judges, but it also makes very instructive material for the judges of other jurisdictions. The purpose of the book is, in her own words, is to trace the history of patent law in India and to capture the rich jurisprudence that has been developed by the Indian courts, which is yet to be fully exposed to the global ecosystem. Well, in the last few days, the judges who've been here as part of the World Intellectual Property Masterclass have been very much exposed to some of the richness of the Indian legal ecosystem, and that is very much thanks to Justice Prathiba Singh, who has been instrumental in organising it. Now, of course, you can read the book cover to cover, and I suggest you do, because it's a great airport read, at least for patent groupies. However, one can also pick and choose the chapters as you want to and you need them. So I had a little canter through the index, and I picked the chapters that I liked the most. Now, the one that I liked was the question of what can be a patentable invention. Now, Justice Singh doesn't stop at the historical recitation and the discussion of cases across the world. She gives the reader a better understanding of the reasoning applied and the conclusions reached. As she points out, in India, there's a nuanced approach, balancing innovation with legal, moral, social and ethical considerations. This is not necessarily the case everywhere, so it's very instructive for those of us from other countries to see how she has explained this. And being Prathiba, she also has had the courage to express her own opinions, not just reporting on the analysis that she has taken from other people's judgments. So I found a lot of assistance and interest in all of the chapters, in particular on compulsory licenses and the evolving law on the interface between intellectual property and competition law. But being Prathiba Singh, she doesn't content herself with the past and the settled situation. She throws out challenges to inventors and those who have charge of the patent system to look or relook for the betterment of humankind and to strive for responsible IP. My reaction to the breadth and depth of this book was why? Why on earth would you embark on something like this? Well, I don't know why she did it, but I'm very, very glad that she did, because it's going to be an instructive read for all of us. It's my thanks and appreciation, Prathiba, are from me personally as a patent lawyer and as a patent judge, and as the first chair of the International Judges Advisory Group to WIPO, but also as a judge who has to make decisions on these matters. This is really an invaluable resource. But to Prathiba, as my children would say, you're a legend. Thank you for being a role model to all of us, to judge it, a role model for judges, a role model for students, to a giver of extraordinary hospitality and organisational skill, to a wonderful lawyer, to a superb patent lawyer, to a contributor to the international understanding of patent law and the role of Indian law in that international context. So, most of all though, I'm very proud to call Prathiba my friend, and I thank her very much for asking me to participate today.
Thank you, Judge Bennett. We are fortunate to have with us today Lord Justice Colin Birss of the Court of Appeal, England and Wales. He has presided over several high-profile intellectual property cases demonstrating expertise in patent law and complex commercial disputes. Patent enthusiasts in this gathering would doubtless know Justice Birss from his decisions in the Unwired Planet case and also in the more recent Thaler decision. I invite you, sir, please, to address the audience. Thank you.
Distinguished guests, ladies and gentlemen, it is an enormous honour and a privilege for me to be addressing you today. I am genuinely honoured to be here. I think I really don't deserve it. It is fantastic. And dear Prathiba, thank you very, very much for inviting me. Obviously, as Justice Bennett described, many of the judges here from all over the world were at the WIPO IP Masterclass, which you organised and for which we're incredibly grateful. It has been a fantastic period, and this is the culmination of that exercise. What I am most astonished about is the sheer hard work that you have put in to produce this book. As you know, I do a bit of dabbling with writing textbooks on patent law, so I think I can say from authority that I know how difficult it is, and I know just how much work you must have done. But what is wonderful, genuinely wonderful, is to read this new voice in patent law internationally. You have added an Indian voice to the international discourse on patents. And it is, if I may say so, genuinely, it is India taking its rightful place in that discussion. Now, funnily enough, maybe because Annabel Bennett, Justice Bennett, myself, and I have a funny feeling Prathiba too, we're patent nerds. I'm sorry. And so my favorite chapter is the same one as Annabel. We should have discussed this in advance. I'm sorry about that. But it was. It's the patentable subject matter chapter. And actually, do you know, it really is worth a read. Taking the whole textbook cover to cover may be a bit of an ask. But I recommend that patentable subject matter textbook, chapter 5. And for me, as an English patent lawyer, what was so interesting, and it's exactly what I was referring to before, is the way that Prathiba was able to locate the current Indian law in an Indian context and then connect it to the international context. Because there are some specific pieces of Indian patent law, which, shall I explain? Would you like to hear? No, you don't want to hear the detail. There's some really interesting stuff in there about how India deals with its own context in the context of patent law. And my favorite is about the idea that you can't patent a new use for an old thing unless it's a genuine innovation. And that is an Indian idea, and it's a fantastic idea, and I want to copy it, if I may. Now, my other favorite, I have to say, is the chapter on standard essential patents and FRAND. Now, I have to tell you, ladies and gentlemen, you don't know the danger you're in if you put me on a stand to talk about standard essential patents and FRAND. We could be here for a very, very long time. But I can save you the bother because Prathiba has summarized the international decisions, which include a couple of mine, and summarize the Indian decisions and put them together in a really good way. So you don't have to listen to me, you should read Justice Singh. Now finally, Prathiba herself, the person. You know her. I have privilege to know her a bit. You know her much better, but I know her. She has real warmth. She has a razor-sharp intellect. If you've not experienced that intellect, you really need to. She has the most steely determination of any judge I know. It is quite something, and you need those qualities to write a book like this. But the thing I want to end with is this. What I'm so honored to be able to do is to call Prathiba Singh my friend. Thank you very much.
It's no coincidence that the favorite chapter of the entire commentary team is also on patentable subject matter. We're a bunch of nerds as well, aren't we? It's also the chapter that took the longest to write, the hardest to get together, the hardest to put together. I do hope all of you read it and enjoy it as much as we did writing it, but I'm digressing. I'm here now to introduce a voice that brings crucial international perspective. We have with us Dr. Klaus Grabinsky, the president of the Unified Patent Court. Dr. Grabinsky served as the presiding judge of the Patent Litigation Division at the Düsseldorf Regional Court as a judge, and also as a judge at the Düsseldorf Higher Regional Court. Before taking on the role of the president of the UPC, Dr. Grabinsky was the external legal qualified member of the enlarged Board of Appeals at the European Patent Office. I invite you, sir, to share your thoughts, please.
Justice Singh, dear Prathiba, ladies and gentlemen, I had the privilege to read some chapters of Justice Singh's book on patent law prior to its launch of today. I did part of the reading during a 5-hour training ride from Luxembourg, where my court is located, to Düsseldorf, where my main residence is located. And I never looked out of the window during that travel. Justice Singh's book on patent law is a rewarding read for both students and experienced practitioners. For those who are just discovering patent law, it is a stimulating introduction to the subject matter which whets the appetite for more. The book covers not only all aspects of substantive and procedural patent law, it also deals with licensing, the interface of patent and competition law, in particular standard essential patents and friend licenses. The book addresses these topics from both a comparative and a historical perspective. Its focus is on the patent law of India, but important developments in other jurisdictions, common law as well as civil law, are equally shown so that the reader receives a comprehensive overview of what is relevant to the specific topic. In addition, the historical development is presented, which is necessary for a better understanding of the current state of patent law. And excuse me, I'm now going into one chapter because it was such a pleasure reading this. In chapter 3, on inventive step, the question of how to adjudicate obviousness is addressed. This is, as all practitioners know, one of the most difficult and often decisive issues to be dealt with in a patent case. Based on the relevant case law and legal documents, Justice Singh gives not only an accurate overview of the respective approaches in India and various other jurisdictions, but also quite some valuable, I should say most valuable, practical advice. Most importantly, in order to adjudicate an inventive step, obviousness, she gives the following recommendations. Take the judge back to the point in time when the invention did not exist, the priority date. Show the state of the art at that time, and then, by putting oneself in the shoes of a person skilled in the art, find out whether such person could have arrived at the invention with the help of documents that are put forward. Being a patent judge myself, I wish this had always been taken seriously by party representatives when pleading a patent case. Being a European patent judge myself, I was of course also interested in learning about the reception of case law from the old continent in Justice Singh's book. She brilliantly summarizes the landmark decision Huawei Seti of the Court of Justice of the European Union, and the chapter on Standard Essential Patents, SEP, and FRAND. If you want to learn about FRAND negotiation process, which is also called the FRAND dance, as provided by the European Court, for the SEP holder, in order to be safe from being accused of misusing a dominant market position, just read Justice Singh's book. It succinctly explains all the dance steps the SEP holder must take in order to not be considered unwilling to grant a FRAND license, and all the dance steps the implementer must take to not be deemed unwilling to take such a FRAND license. You see, Justice Singh's book not only teaches patent law, but it is also an excellent dancing school. To sum it up, Justice Singh's book combines theory and practice of patent law in a highly insightful and comprehensive manner, and therefore it is a must-have for judges, academics, practitioners, and students alike. Very much congratulations to you, Prathiba, and thank you very much, and thank you also for having me invited to this wonderful event and for having a very friendly relationship. Thank you very much.
Thank you, Dr. Grabinsky. The moment we've all been waiting for, and it's a few minutes ahead of schedule as for the schedule that we planned, but the moment's here. The official launch of the commentary will now be carried out by our esteemed guest of honor, Mrs. Nirmala Sitharaman, I'm excited, the Finance Minister of the Government of India. I'd also like to invite on stage Mr. Maninder Singh, Senior Advocate, to accompany the dignitaries on the dais, please, sir, as they prepare to unveil the commentary. Thank you, esteemed dignitaries. I just shared a moment with my colleague. I can't believe it's done. It's finally launched. It's really a moment for us today. I'd like to now welcome our chief guest for the evening, Mrs. Nirmala Sitharaman, the Finance Minister of the Government of India. In this role, Mrs. Sitharaman has played a crucial part in formulating and implementing various reforms aimed at boosting economic growth and development in India, and has played a pivotal role in shaping India's economic policy and reform. It was under her leadership that the IP think tank was constituted, which resulted in Thinking India's IP policy, where Justice Singh played a crucial role. I'd like to invite Mrs. Sitharaman to say a few words, please, ma'am.
Justice Prathiba Singh, dignitaries on the dais, eminent judges of the Supreme Court and the High Courts, experts from the legal arena, invited guests. It's an honor that I'm standing before you to participate in this very important day for Prathiba and also for all stakeholders in the patent and copyright world. If I can start by saying, in India's long history dealing with patents and copyrights and so on, the last 10 years have seen quite a few milestones, and in each one of them, which I'll very briefly recount, in each one of them,
Justice Prathiba Singh, as justice or much more even before it, has had a very significant role to play. So 2015, the current government under Prime Minister Modi set up a think tank to look at IPR in India, that is the intellectual property right, and how do we handle it? Is there a policy? What is the kind of policy we want? So a think tank was formed, and Justice Prathiba Singh, then not justice yet, was a very active member. She contributed immensely to it. 2016 was when the policy was framed, and post that, a very significant milestone was when, in April of 2021, the Intellectual Property Appellate Board, which existed till then, was abolished. And all pending cases before the IPAB, the board, was transferred to the respective high courts. But the high courts were, as it is, faced with a backlog of cases, and those cases related to intellectual property, however important, however very critical for the development of the country, and however much the government placed emphasis on them, had to become a part of this backlog. But and in the meanwhile, the Parliamentary Standing Committee started noticing that this backlog is not going to be healthy at all, and had taken a very strong position that high courts may just not be able to cope with the backlog, and therefore an appellate tribunal, which was just only a recent or a few years back, was abolished. The standing committee took a position that we should go back to appointing the appellate board again. But the abolition happened as a result of the Supreme Court's verdict. But then, post taking that position, the Parliamentary Committee also wanted to review the intellectual property related matters, with just then the policy having been framed in the country. It had called a lot of stakeholders, and many who were seriously involved in the process of making the policy itself, and also looking at how high courts were taking up their responsibility, appeared before the standing committee. And post the review, much to all our surprise, and pleasant surprise at that, the standing committee took a favorable position that indeed the high courts are doing all right, and that they should continue doing it, only because, and I singularly put this credit to Justice Prathiba Singh and to the Delhi High Court, led by its Chief Justice, for having the Chief Justice of Delhi High Court had given a big support, and with the intellectual and the footwork of Justice Prathiba Singh, the Delhi High Court set up a IP bench. And the way in which the bench rapidly handled issues related to the intellectual property matters actually gave the confidence to the Parliamentary Standing Committee. And I reiterate, for a Parliamentary Standing Committee to change its position and say, nope, it can back again be with the High Court where it is now, and went further to say every High Court should create an IP bench. So singular contribution of the Delhi High Court, the Chief Justice and Justice Prathiba Singh, to show that where there is a will, there is a way, and Delhi High Court overcame all the difficulties that it faced to set up this bench, and that bench actually proved that it was efficient in clearing up the backlog, streamlined the way it was being handled, and gave confidence that it doesn't matter that there is a backlog, but if it is a dedicated bench, things can move. And especially with the interest in commercial matters, and also in India, the policy going towards greater innovations, a greater patent, greater copyright, greater trademark registrations within India. So I begin on that note. If she has today succeeded in giving us a fantastic tome which can be referred to when you're talking on matters related to patent laws, not just in India but anywhere in the world, it is because she has gone through it as a leading advocate and subsequently also understood the process through which a bench can become expeditious in these matters. A little was said about how India is looking at handling IPR. I would take a few minutes to explain a few things on that because we are talking about this subject with such interest today. In India, of course, IPR laws, the policy, are all being given a certain kind of push because in research and development, in patenting and innovations which are happening in very big scale in India now, because the environment is being made conducive for that purpose. In that, we keep balancing the protection aspect for those who innovate, those who seek the patent, those who get the patent, together with looking at the commercial propositions with which they can be of use for our society. So the IPR laws, we are trying to make them as a facilitator, booster, and not certainly a barrier in the process of R&D. We've taken quite a few steps, and I singularly thank Honorable Prime Minister for this particular policy, which after a lot of consultation has come up in 2016. A few things were taken up soon after that. 8 different items, all of whom have something to do with intellectual property, have all been brought together, meaning they are under one umbrella. As a result, you're not running from pillar to post. Everything to do with the policy management on intellectual property rights are now under one framework, be it patents, trademark, industrial designs, copyrights, geographical indications, semiconductor integrated circuit layout design, trade secrets, and also plant varieties. So all 8 of them are broadly under the same framework, and the legislative framework is TRIPS compliant. It's necessarily for safeguarding IPR, and we certainly, as I said earlier, are trying to balance between patent protection as much as development concerns which they have to address. Very many steps have been taken in order to help greater patenting and also registering of patents. We have reduced the fee for startups and MSMEs and also for education institutions, and we are fast tracking examinations and making sure specific applicant groups are treated with a bit more care and with efficiency. We've also established National Intellectual Property Awards to recognize individuals and organizations that have created as well as commercialized IP. There is a particular scheme which the government has brought out called a scheme for pedagogy and research in IPRs for holistic education and academia. Under this, 37 IPR chairs have been established by Government of India. And this promotes IPR study and research, and also for commercialization of IP. Technology innovation support centers have also been set up. They are set up in central universities and state universities, and since 2020, that is within 3 full years, 12 established such centers of TISC, Technology Innovation and Support Centers, have been established, and they have filed 734 patents within the last 3 years, conducted 1,752 IP awareness programs, and commercialized over 100 patents. You are aware that there is a cell for IPR promotion and management. We call it in short CPAM. That was also created in 2016. CPAM has been instrumental in raising IPR awareness through tailored resource materials and in programs in various educational institutions and industry bodies. Till today, they've conducted 1,200 events and 3,000 plus academic institutions. Our government has also signed, I think in 2019 itself, government has approved the accession to 3 important agreements. The Nice Agreement concerning international classification of goods and services for purposes of registration of marks. Vienna Agreement establishing the international classification of the figurative elements of marks. Locarno Agreement establishing an international classification for industrial design. We've approved accession of India into these agreements. So that actually immediately opens up a lot of avenue for us to align ourselves in many of the copyright and IP related matters with what's developing globally. Traditional knowledge digital library has also been established. This was established even in 2001, but today it has the advantage of so many different databases, all of which are available for them. The traditional knowledge digital library was restricted to 14 patent offices only. But in 2022, we have approved expanding access to various stakeholders like businesses, research institutions, and also educators on paid subscription model. All these have actually helped us progress rapidly in various different dimensions of IP, about which some parts of which the previous speakers have elaborated. But the biggest advantage which an Indian author like Prathiba gives us in India is that she's contextualized India's IPR trajectory with what is happening globally. And it was really music to my ears when I heard an eminent speaker before me identify that Prathiba's contribution singularly stands out for how she has framed the Indian IPR ecosystem, government policy, and the way in which our courts are handling IPR related matters vis-a-vis what's developing outside, but bringing in that necessary Indian element. I'm owning it up as Indian, but essentially an element which brings the important element in commercializing patents, that is, looking at how it's going to help the society. And unless a country which is like India, diverse in its developmental perspectives and goals, thinks about those aspects, you're going to miss out and probably lose out on only commercializing patents. It is necessary to bring it down to the earth and tie it to the roots, which is necessarily reflected by the diversity of India's development being spread across this vast country. I think this is a very big contribution that Justice Prathiba Singh has made, not just for jurisprudence, but also for India's contribution on a very contemporary topic which is developing in such rapidity because of technology getting into all our lives. And this book, I think, is going to be for several hundred years as the core reference material on intellectual property. I wish Prathiba all the very best. She's got the right mix of a practicing judicial officer, a thinking mind in a very legal sense in that way, but I think ultimately a good teacher in that she makes things simple and easy to read, all of which is in this 2-volume book. I wish her all the very best and thank you very much for inviting me today here.
Thank you, ma'am, for your illuminating words. Just pick off from the last thing that ma'am said. Continuously while we were writing, while we were working to get the commentary ready, ma'am would say, keep it simple, make the sentences shorter. It's already complex subject matter. We can't have complex English also just confusing our readers. And that's something we've tried to constantly keep in mind while preparing the commentary. We all know Justice Prathiba Singh, we all know her capacity for work, and we all know, we've borne witness to just how she fulfills every task she takes on. A small group of lucky few got to witness the sheer genius at work when she spent hour upon hour crafting every sentence that finds its place in the commentary. The time spent researching, writing, rewriting, editing, correcting, formatting, fixing. Just creating this work, it's been monumental. And that effort, I know, dear readers, will reflect in each page as you read the commentary. I'd like to invite on stage the woman of the hour, Justice Prathiba Singh, to tell us more about this.
A very good evening to all of you and to this August gathering in Bharat Mandapam. Honorable Finance Minister, Nirmala ji, my friends on the dais, the publisher, Mr. Gauri Shankar, Honorable Supreme Court judges, present and retired, High Court judges, retired and present, including the Acting Chief Justice, Justice Manmohan, the Attorney General for India, Mr. Venkatramani, the Solicitor General, Mr. Mehta, additional Solicitor Generals who are here, senior advocates, representatives from embassies, academic institutions, my friends from the WIPO Masterclass with whom we've spent the last 3 days, the IP fraternity, Mrs. Sangeeta Jetli and her family, Mrs. Sorabji, my own family from Delhi and from Bangalore, friends, ladies and gentlemen. I have half an hour so I can actually read the book today. But I don't want to do that and bore all of you. The long journey of this book, culminating with the event today, is actually a momentous day in my life. It is a journey of aspirations, encouragement, and hope. Hope not just for individuals, but hope for the country. Let me start with aspirations. Aspirations are those which one has, and in my case, it was aspirations which I had when I practiced as a lawyer. When we appeared before the High Court or the Supreme Court, me and my team of lawyers and juniors and colleagues, we always used to cite Terrell on patent law. Terrell's 16th edition is out, and the man who edits it is on the stage. Call him Birss. The authors of the Novartis judgment are with us today, both the judges sitting in the audience. So, what are the aspirations? The aspirations for me as a lawyer were that we needed books in India to document the history and the growth of patent law in India. We had the monumental work done by two great committees. One, Justice Bakshi Tekchand. He wrote the first report in post-independence India for amending the patent law which was existing at that time. And the second is Justice Rajagopal Iyengar. Both of them took 20 years to write their reports. They reviewed the law of more than 45 to 50 countries. And please believe you or me, it is impossible without the internet to do that. Anyone who reads these reports, which is now part of the appendix of this book in volume 2, will realize what a difficult effort it was for both of those judges. This book is a homage to those two reports and to those two judges who wrote those reports. These two reports were not just reports which remained on paper, they were reports which changed India. And I'll tell you the reason why. The 1911 Act got amended. We enacted the 1970 Patents Act, which has remained good till date. It was their recommendation that after having reviewed the law in US, in Canada, in Europe, France, Italy, every other major country in the world, that during the course of development of a country, it is important to not grant product patents in food, medicine, chemicals, and other important technologies. So from having a product patent regime till 1970, we shifted to a process patent regime. Until TRIPS happened in 1995, that's for 25 years, our pharmaceutical industry grew. Which is how early 1900s, most of the developed countries grew. And that led to what the pharmaceutical industry is today, which led to all the vaccines which were manufactured indigenously in India. We couldn't have done it without the pharmaceutical industry. And a lot of credit goes to these two reports, then the change in the patent law, and then back we were into the product patent regime 25 years later after the TRIPS regime. So these two reports had a very important role. And what was the aspiration, connecting back? The aspiration was to have a book for Indian patent law in the context of the globe. You will not believe if I tell you that there are more than 1100 Indian patent judgments that we reviewed as part of this commentary. And more than 500 of them are cited in the book. None of us knew that there were so many judgments in Indian patent law. And all the judges whose judgments are cited in the book, one of the features of this book, if you look at the brochure that's been circulated, is to list all of these judges. It starts at page 39. There are a total of 176 judges from India and several judges from abroad whose names are found in the book. This is a unique feature of this book because the two reports with the legislative history and the judges and their judgments was not available in one place. So the aspiration was to make such a book available if possible, and this is actually only a humble effort to that. Let me come to the second aspect, and that is encouragement. Encouragement for me was in the form of kind words when I was designated a senior advocate in December of 2013. There was a small dinner hosted by our own colleagues in the office. That's where Mr. Jaitley and Mr. Salve spoke and told me it's time to write a book. And the video which you saw, which my son presented, was a video clipping 11 years ago. It took so long to make that encouragement become a reality. So Mrs. Arun Jaitley and Mr. Salve had a big role in putting the seed in my head to write a book. And I've had the privilege of working with Mr. Fali Nariman, whom we really miss today. And I thank Nina Nariman for having come here and for having read Fali sir's message. Let me tell you what happened with Fali sir. When we wrote the initial chapters, I made a binder of 5 chapters and took it to him in 2021. I left that 5-chapter binder with him, and 2 days later I received a long letter, a 1-page letter from him telling me that it's not enough to look at traditional concepts of patent law. It's necessary to look at new technology and how patents are going to be dealing with new technology. And therefore, in this book, I have dedicated chapter 20, which deals with artificial intelligence and patents, to Fali sir. We really miss him today. The other legend I would like to acknowledge is Mr. Soli Surabji. My first trademark matter, which I had the opportunity to work, was the Sumit matter when I was working in Mr. Anand's office. It was the first reported case where I briefed him, and whenever I met Soli sir, either in the corridor, in the High Court or anywhere else, he'll say, "Hey Prathiba, when are you writing your book?" Every time he would say. And today is his birthday, and we have Mrs. Zena Surabji here. Nothing more could have been better. Then I come to encouragement by none other than Mrs. Nirmala Sitharaman, who is here. Maninder and me have known her for more than 15 years. She reposed enormous confidence, put me in the think tank. Mr. Narendra Sabharwal is here. He was part of the think tank. It was headed by Justice Prabha Sridevan. We all drafted the IPR policy, and she reposed a huge amount of confidence in giving us that opportunity. And this policy has actually not been a paper policy. It is being implemented from what you heard today from her. My friends Annabelle, who is herself a legend in Australia, Colin Birss, who is the editor of Terrell, he has written some of the most mind-boggling judgments in patent law. It takes us 3 reads to even understand it. Several lawyers who are in this audience cite his judgments before us and tell us, look at what Justice Birss has said. So recently he's done something next level. When there was a question as to whether artificial intelligence inventions should be given patents, he was the dissenting judge in the Court of Appeal who said, yes, please give a patent. It was a 2:1 decision, Colin, isn't it? It went to the UK Supreme Court, and the UK Supreme Court said, as of now, as the law as it exists, we can't give patents to artificial intelligence inventions. We also have Klaus Grabinsky. I keep calling him the king of Europe in patents, and he keeps saying I'm a CEO of a startup because the UPC started only last year. He and Rian Calden, the vice president, are here. So patents is now global, it's integrated, and India is a part of it. It's wonderful to have all these legends in patent law sitting here with us today. The seed for the commentary was sown in 2015 when the publisher Thomson Reuters approached me. They actually wanted me to write a student's book on IPR. And I said, no, I want to write only on patents. I don't want to write a student's book on IPR. And that's how it started. So 15 to 17, I wrote a few chapters. When I was elevated, I stopped it. It took me 4 years to restart because it isn't easy sitting on the bench and learning how to write judgments. So 2021, I restarted the book. It was very tough. It was a huge difficulty because it was COVID. Most of the book was dictated online to stenographers with all the team consisting of Anusuya, Ashutosh, Vrinda, Skanda, Devanshu, everyone. They were the core team. We worked hard through the COVID pandemic for 2 years, and the dictation was completed. During this period, the commentary team went through a lot of difficulties. Anusuya gave birth to twin children during this period. Vrinda lost her father during this period. But the commentary team was completely dedicated. We put in hours and hours of work during the COVID-19 pandemic. But in 2021, as Nirmala ji just said, there was another blow, which turned out to be a silver lining. And that was the setting up of the IP division. While we were finished almost with the dictation, and we said, okay, we are now ready to publish, we had almost 300 judgments of the IP division of the Delhi High Court to cover. And some of the authors of those judgments are all sitting here. Justice Naveen Chawla, Justice Sanjeev Narla, Justice Jyoti Singh, Justice Amit Bansal, Justice Hari Shankar, all of them. So many judgments, and we felt that we can't publish the book without all these judgments being included. So we started the whole process once again, covered all the 250 judgments again, and then incorporated it into the book. In the last lap, the dictation was finished in December 2023. We have had one of my ex-law researchers, Shivam, who really did a lot of hard work, indexing, case law listings, final editing with the publisher, coordination, everything. Some of my LRs have really worked very hard. One of them is Aman. I would like to make a special mention of Zoeb Hussain and Adarsh Ramanujan, who reviewed some of the chapters for me because I didn't want to go wrong. I wanted to make sure that people who know the law are looking at the book and giving me their inputs. The publisher's team was with us all along, matching up to our high standards. When the printing of the cover didn't turn out well, I had to call up the publisher's person handling printing in Madras, and I said, you take the flight in the morning tomorrow, otherwise this book is not getting printed. So he came all the way from Chennai, worked 48 hours continuously with the printer to get the printing done. So as you can see the product today, it is a combination of a lot of hard work by a number of persons, and I want to own up and say, any mistake is purely mine. I must say that after the book has been printed, in the last 10 days when it came to the house, I have avoided reading it completely. Because I know that if I read it, I'm sure I'll start finding faults in it, and I'll then be very underconfident to speak before all of you today. So I have not read it after it has been printed. One author, in fact, told me that one should publish a book when it's 80% ready. I'm quite sure it is more than 80% ready, but I'm also sure that it's not 100% ready. We will leave the 100%, remaining of the 100%, for the next inputs and the next editions. The commentary covers various traditional aspects of patent law, novelty, inventive step, infringement, defenses, but also, as all the speakers on the dais have spoken, it deals with complex issues like exhaustion, interface with competition law, taxation and patents, the overlap between patents and other regulatory authorities like Drugs and Cosmetics Act, Insecticides Act, Biodiversity Act. A special chapter has been dedicated to monetary aspects of patents such as valuation, taxation, etc. With all the Supreme Court and High Court judges here, I can say that section 3D is my favorite section. All the IP lawyers are laughing and they know it. Section 3D finds mention in maybe 25 chapters, in the 20 chapters of the book. It's there in a large number of chapters, evergreening. I remember very clearly that the entire effort in this commentary has been a lot of hard work, and it has what it has come out to be because of the entire team which has worked on it. There are a few things that I wish to say for another 5 minutes, I'm sorry. I want to remember my grandmother, Srimati Pramila, who is not here with me today, she would have been elated to be here. She never made me feel the absence of my mother, who I lost when I was 6 years old. She made sure that despite all the struggles, she could make me a lawyer. She could send me to Cambridge. It was a tough decision for her and for my family. But she reposed huge confidence, and that's why I'm here today. I want to remember and acknowledge the presence of my mother-in-law. She is the pillar of our family. She's been a mother, standing with us, literally bringing Maninder and me up throughout. I was married when I was 25. She brought us up, she brought our children up. She instilled wonderful values and spiritualism in us. We are blessed to even have her in the hall today. Thank you. I cannot but acknowledge the contribution that Maninder has made in my life. He is When I came to Delhi in 1992, I didn't know anyone. He gave me the identity that I have today. He stood like a rock all through, whether it's happiness or anxiety. Day before yesterday, when I told him, Maninder, this book is taking everything out of me, he said, nothing doing. You have to just keep going. That is what Maninder is. And without him, nothing would have been possible. My children, all 7 of them now, 5 of my children, we have an extended family, and the 2 inclusions in the family newly, who stand with me and keep me grounded, give me a lot of comfort. My extended family in Delhi and from Bangalore, they've given me their unflinching love. My colleagues in the Delhi High Court, with the leader who's here, have given me enormous strength and made me resilient. Thank you to each one of you. The soulful music today by Kanika and by Manmeet was a great start. The video by Karmanya put together treasured messages with Mr. Jaitley and Mr. Salve were the beginning of the idea of the book. All my ex-colleagues who are standing here and the staff of Maninder's office who's put this together, we have a special relationship with each of them and their families who are all here. Each of you who is in this hall is special to us, and your enduring presence will be really treasured. I now want to end with the vision for the book. India is in a unique position in IP. Indians create annually the largest quantum of copyrighted works. Indian businesses own more than 80% of the trademarks and now more than 50% of the patents. This used to be only 20% just 4 or 5 years ago. The innovation landscape has undergone a complete change. Indians are innovating more and patenting more. The judicial system has to prepare for this thunderstorm of patents, which would definitely reach the courts in the next decade or so. We need more literature on the subject, and I would exhort all the youngsters who are here to write and publish more in the field of IP. In the pharma space, India has proven its prowess. A large quantum of IP disputes now, India is the go-to jurisdiction. You'll find that if there's a litigation, patent litigation in the Delhi High Court or maybe in the other high courts, 2 or 3 of those cases will be simultaneously going on in other jurisdictions. India is one of the top 5 jurisdictions in the world for patent litigation. Some of the best judicial precedents are coming out from India, and there are several highly competent judges who are authoring these judgments. And most of them have been acknowledged in this book, and I apologize if there's anyone who's missed out. The patent law, which found the foundation in the 2 committee reports, has now become well ingrained in India. Going forward for India, the vision is 360 degrees. We look at ourselves in the globe with confidence while maintaining the balance between patenting and the balance between the large number of citizens and population in our country. Our societal needs, economic needs are very different. There are new technologies which are posing questions: AI, blockchain, NFTs, everything. How does patent law span out in these technologies? The fundamental principles of patent law itself could undergo a change as we debate patent law, because patent law is meant to reward human innovation and human creativity. Are we willing to give it to machines? Should we or should we not give it? Huge challenges are there in the world, like climate change. How are we going to give patents to environmentally safe technologies? Will giving of patents stop the environmentally safe technologies from being spread out? Therefore, the last chapter of this book, in fact, ends with saying, and I read that sentence to leave that thought with all of you. In conclusion, it needs no emphasis that patents are a means to the goal, i.e., incentivize innovation for the benefit of society and the world. Patent owners have to therefore be conscious of their role of ensuring the greater good. The COVID-19 pandemic taught us that innovation, patents, and enabling access to innovation is of crucial importance for the benefit of humankind. Thus, in the context of more and more diseases, health constraints which affect human beings, as also issues concerning climate change, there is a need to strive for responsible IP. It can't just be IP, it has to be responsible IP. I now want to end by saying that the purpose of this commentary is to showcase the rich jurisprudence that is developed in India in the field of patents. I look forward to receiving inputs from the IP community for any input which could make it better in the later editions. One question that has been plaguing all of us when we wanted to publish this commentary: what would I do if this commentary is cited before me? So I write in the foreword that to all the lawyers who want to cite my commentary, you will do so at your own risk and your peril. I want to add that I may disagree with my own view. And finally, it is definitely not binding on me and none of my colleagues who are here in the audience. Thank you so much, ladies and gentlemen.
Thank you, ma'am, and congratulations on your big day. Before we move on to the formal vote of thanks, there is a personal vote of thanks that I would like to make on behalf of the team that worked on the commentary. Ashutosh Kumar, Devanshu Khanna, Brinda Bagaria, Skanda Shekhar, Shivam Kaushik, Aman Sinha, and me. We want to thank you, ma'am, just for giving us this opportunity. You know what it means to each of us, and you know what you mean to each of us. Thank you, ma'am. Thank you. And now, to formally bring the event to an end and to express our gratitude, I'd like to invite Mr. Gauri Shankar Nateshan to present the vote of thanks.
Ladies and gentlemen, good evening. I stand before you today with a heart full of gratitude as we come to the close of this wonderful book launch. On behalf of Thomson Reuters, I extend a warm and heartfelt vote of thanks to each and every one of you for gracing this occasion with your presence. Your presence has added prestige to this event, and we are grateful for your support in promoting this book. Ms. Nirmala Sitharaman, Honorable Finance Minister of India, has been actively involved in economic and policy matters, playing a crucial role in shaping India's fiscal policies and addressing economic challenges. During her tenure as the Finance Minister, great strides have been taken to boost economic growth, implement reforms, and manage the financial aspects of the country. Thank you, ma'am, for taking this time to release this book and grace the occasion. Lord Justice Colin Birss, Judge of the Court of Appeal of England and Wales, is recognized for his expertise in intellectual property law. He has presided over various cases involving patents, trademarks, and copyrights, demonstrating a deep understanding of the complex legal issues in the realm of intellectual property. Thank you, sir, for taking the time to be part of this event. Dr. Klaus Grabinsky, President of the Court of Appeal and Chairperson of the Presidium of the Unified Patent Court, is the co-author of a commentary on the European Patent Convention and a commentary on the German Patent Act. Thank you, sir, for your being part of this occasion. Dr. Annabel Bennett, former judge of the Federal Court of Australia, additional judge of the Supreme Court of the ACT, has presided over several high-profile cases, and her contributions, particularly in IP matters, have been notable. Thank you, ma'am, for your presence on this occasion. Mr. Harish and Salve could not be present here, but then he was here virtually. Senior Advocate of the Supreme Court of India, former SG of India, and Queen's Counsel for the Courts of England and Wales, is a leading arbitration lawyer. I would like to thank him for his comments on this occasion. Late Mr. Fali Nariman, legendary jurist who made enduring contributions, unfortunately could not be present physically. And I would like to thank Nariman for presenting his words to us.
Thank you so much.
I would like to thank the distinguished judges of the Supreme Court of India and the High Courts of India on this occasion I would like to thank the Learned Attorney General for India and the Learned Solicitor General for India and other distinguished guests on the occasion of this book launch for your presence here. This vote of thanks would be incomplete without a special word of appreciation to the team at Newgen Knowledge Works who pulled out all the stops to meet deadlines and published the book in time for today's launch. And a word of appreciation for everyone who worked behind the scenes to make this event seamless and smooth. And last but not the least, I need to talk about this. I should have spoken probably first. Our most sincere and enormous gratitude goes to our esteemed, much feted, and awarded author, Justice Prathiba Singh, for writing this remarkable book on patent law. Justice Singh was, as you all must be aware, a leading intellectual property lawyer before being elevated to the bench, and she has become the first Indian judge to be elected as an honorary fellow of the Hughes Hall, University of Cambridge, UK, in 2022. Justice Singh, your writing, dedication, and passion have brought us a work that will undoubtedly leave a lasting impact on its readers. We are honored to have been part of this journey with you. Thank you all once again for being part of the celebration, and we wish you a wonderful evening. Thank you.
Thank you. May I request judges, dignitaries, officials from the embassies to please proceed for high tea. And I urge everybody else in the gathering to just be seated for a few minutes, please, just to help us organize the exit from the room. I also do want to say that there are copies of the commentary available for purchase, and please make sure that you get signed copies from the author before the end of the day. That's something we're all looking forward to. I must also add that high tea is being served one level below, and just as you go out from the escalator that you'll see just as you move out. Oh, mic down.